Good afternoon, everyone. Good afternoon, everyone. Welcome to session 8 of the Delhi State Legal Services Authority Learning Series. Today, the topic is Role and Responsibility of a Criminal Law Practitioner during COVID 19 lockdown. We are privileged to have with us as resource person Mr. Sidharth Luthra, Senior Advocate, Supreme Court of India. The topic which has been chosen for today is an important topic. We all know the proceedings are being conducted in High Court, and now in the district courts of Delhi, we are going beyond the urgent hearings. So, with this vision, our member secretary, Mr. Arora, was of the view that we need to have this discourse with all Delhi legal aid lawyers so that we can discuss the intricacies involved when there's criminal law functioning with the technology involved. Taking no time further, I would request our member secretary, Mr. Kavaljit Arora of Delhi State Legal Services Authority, to share his aim and vision for the topic for today in detail. Over to you, sir.
Namaste. A good afternoon to my dear friends. Welcome to the next session of learning series of Delhi State Legal Services Authority. दोस्तों, आप सब जानते हैं कि हम सब, हमारा समाज, हमारा देश, बल्कि ये सारा संसार किस मुश्किल दौर से गुजर रहा है. This pandemic of novel coronavirus that has posed unprecedented challenges for everyone. Individuals, institutions and governments, they are dealing with it and are trying to defeat this pandemic. Friends, to combat this pandemic, which is posing immense threat to the citizens of our country, a national lockdown was declared, which is still in place, but of course, with some major relaxations now. Friends, owing to this national lockdown and threat of coronavirus, we all know that functioning of the courts across the country also got immensely affected. Earlier, it was restricted to matters of extremely urgent nature, and now the courts are dealing with matters of urgent nature. As Shreya told you, not only the High Court but the district courts have resumed some functioning, and the purview and scope of this urgent nature matters that has also been expanded a little bit now. दोस्तों याद है वो 26 नवंबर 1949 का दिन when we adopted our constitution and took a pledge that we shall provide justice, social, economic and political to everyone. This pledge, friends, was taken by all of us for each other. So while we are functioning, is it in our or working in our individual capacities, or we are functioning or working as an institution, we need to honor this pledge, whatever be the situation. चाहे वो ये pandemic coronavirus की situation हो, or any other situation, we are committed to that particular pledge, the pledge which we had taken. We cannot deny anyone the justice or at least access to justice. तो दरवाजे जो हैं कोर्ट्स के वो बंद नहीं हो सकते हैं, और सिर्फ यही एक रीज़न है, ये प्लेज जो हमने लिया, अपने आप को दिया, यही एक रीज़न है कि जो न्याय व्यवस्था है, जो न्याय प्रणाली है और जो कोर्ट्स हैं हमारे, उसके दरवाजे उन सब लोगों के लिए जिनको उस न्याय की ज़रूरत है, उस जस्टिस की ज़रूरत है, वी कैनॉट क्लोज. सो दे से दैट जो एडवर्स सिचुएशन, एडवर्सिटी, इट अफेक्ट्स ऑल, एंड द वर्स्ट अफेक्टेड आर ऑलवेज द वल्नरेबल सेक्शंस ऑफ द सोसाइटी. और दोस्तों, ये वही वल्नरेबल सेक्शंस ऑफ सोसाइटी हैं जिनके लिए हमारी अथॉरिटी की एग्जिस्टेंस है. जो सब they become part of that section 12 of Legal Services Authority Act, under which we function, Legal Services Authority function, and all these class of citizens who are part of, who fall under this section 12 of Legal Services Authority Act, जिनके लिए हम काम करते हैं, जिनको redress दिलाने के लिए, जिनको access to justice दिलाने के लिए, we are all committed. Friends, situation conceived due to this pandemic has resulted in germination of some other potent issues which are also affecting the citizens of our country, and those effect which are being caused by these resultant issues, they can be proximate, they can be distant also, We all know that, and we can perceive that because of this situation, many have lost their employment, many have lost their job opportunities. There is resultant loss of income for many, and this loss of job opportunities, loss of income, that has given rise to frustration. And because of this frustration, the distances and differences have increased in relationship, be that of, आप चाहे उसको लैंडलॉर्ड टेनेंट की रिलेशनशिप ले लो, हस्बैंड वाइफ की रिलेशनशिप ले लो, लेंडर बोरोवर की रिलेशनशिप ले लो, एम्प्लॉयर एम्प्लॉय की रिलेशनशिप ले लो, so on and so forth. Besides that, this loss of income and loss of job opportunities, that in itself has a potential of increase in crime rate in the society. So for all that, we need to gear up. We need to know that lots and lots of persons would be requiring to step in, to come to the courts for getting redress to all their grievances, all their differences, all their disputes, which are uh, being given rise to because of the situation which has arisen due to this coronavirus. दोस्तों, आप सब जानते हैं कि इन दिनों नए केसेस की फाइलिंग भी कोर्ट में दैट हैज बीन restricted because only the urgent nature of cases जो उस एम्बिट में आते हैं, they are being entertained. जिस वजह से जिस जगह पे आज हम खड़े हैं, वहाँ से ये कहना या प्रेडिक्ट करना दैट व्हेन नॉर्मलसी वुड बी रिस्टोर्ड, व्हेन रूल्स ऑफ social distancing would be no longer necessary, or when the courts will start functioning at its normal pace, in its normal manner, that is very difficult. लेकिन एक चीज जो बिल्कुल साफ और स्पष्ट नजर आती है ना, वो ये नजर आती है that as and when the functioning of the court will resume, there will be flood of new cases, be it civil, criminal, matrimonial, or of any nature. There will be flood of cases. And one more thing which is certain and clear, that the working pattern of the court जो पहले होता था, that will also go a sea change. That has already changed, and what used to be the normal earlier, that won't be the normal functioning of the court in the times to come, in the days to come. So friends, it is for this situation that we need to make ourselves ready and prepare. We need to learn the technology and the etiquettes of virtual appearance in the court, so as to maintain the decorum of the court. That has to be maintained. What was there, that will remain. That decorum has to be maintained. So we need to know the etiquettes also of virtual appearance in the court. Friends, this pandemic and the resultant situation no doubt has posed, what I feel, that no doubt it has posed daunting challenges to us. But I'll say, you just look at the positive aspect of it. I'll say that it has also provided us an opportunity to equip ourselves with the technological advances, with the technological arms and ammunition that would be required to make us battle ready for to take on the inundation of new cases that is going to be filed in court as and when normalcy, or say some of the normalcy, would be restored. And these cases we need to fight up, we need to take up for the vulnerable sections of the society who would be coming to us. तो किसी ने सही कहा है कि एक सा मौसम हमेशा कब रहा है, एक सा मौसम हमेशा कब रहा है, तू भी बदल फलक के ज़माना बदल रहा है. तो वी नीड टू चेंज. दोस्तों, हमें ज़रूरत है बदलने की, हमें ज़रूरत है अपने वर्किंग स्टाइल को बदलने की, हमारे आर्ग्यूमेंट करने के स्टाइल को बदलने की, हमारे पिटीशन फाइल करने के स्टाइल को बदलने की. और सिर्फ इस ज़रूरतों को फुलफिल करने के लिए, जस्ट टू बिल्ड अप आर कैपेसिटी, आर capability to take on the newer challenges, that at DSLSA we had taken this particular opportunity. ये जो period है, इसको properly and effectively utilize करने के लिए we have started this learning series for all of you, all our panel lawyers. We want all of you to be battle ready. We want all of you to equip with the requisite arms and ammunition that is required for you to take on these newer challenges. और दोस्तों, ये हमारा privilege है that to help and guide us and to show the way forward for the new normal. regarding the court proceeding, especially with respect to the criminal practice. What should be the role and responsibilities of a criminal practitioner in courts in the times to come? We have with us a very eminent speaker, a senior advocate, Shri Sidharth Luthra ji, who is in this field for last 3 decades now. Friends, from him, what I'll request all of you, that from him, we should not only learn the tips and tricks of practicing criminal law, but we should also know the tone and tenor in which the court is to be addressed by all of us. I do hope that all of you, including us in the authority, we would grasp each and every word that will fell from him, and would try to imbibe the same in our working style, in our working pattern, so that हम उन सब के लिए जो हमारे पास आने वाले हैं in the days to come, in the times to come, we can make ourselves, we can equip ourselves, और हम उनकी expectations तक खरे उतर पाएं. सिर्फ एक्सेस टू जस्टिस का सिर्फ ये मतलब नहीं है कि हम उनको एक लॉयर प्रोवाइड कर दें. लॉयर of a quality, and I know, I am proud of all of you. You already have that quality, that devotion, that dedication in you, in all of you. I'm proud of you. You have shown the results in the past, and I'm sure that in future also you would make this authority proud. But the only thing which I want is that apart from your legal knowledge, we now need to know that how that legal knowledge, ये जो procedural aspect, the changes which have come because of this situation, we need to know all those changes. उस लीगल एक्सपर्टीज का कोई फ़ायदा नहीं है अगर हम उसको ट्रांसलेट न कर पाएँ, अगर हम उसको ट्रांसमिट न कर पाएँ टू द प्रिजाइडिंग ऑफिसर. जो कुछ आप जानते हैं, द वे इट इज़ टू बी प्रेजेंटेड बिफोर द कोर्ट, दैट इज़ ऑल्सो ऑफ utmost importance. एंड फॉर दैट मैं ज़्यादा टाइम नहीं लूँगा. I'll request Shreya to introduce our speaker to our panel lawyers to give a formal introduction of Shri Sidharth Luthra ji. So over to you, Shreya. Thank you very much.
Thank you, sir. So, today the topic you all know, the role and responsibility of a criminal law practitioner during COVID-19 lockdown, which would be taken up by Senior Advocate Supreme Court of India, Mr. Sidharth Luthra. Introducing him, we all know Sir specializes in criminal law, white-collar crimes, and cyber frauds. He studied law from University of Delhi, and he did his MPhil in criminology from the University of Cambridge. Sir is also a member of Delhi State Legal Services Authority. We have been privileged from time to time to get inputs from him for our work and functioning. Sir also teaches law, and the ones who have worked with him or are associated with him know the key to hard work, perseverance, and they call him a jurist. So I will not take any time further. I would request jurist who is present with us to take over and to discuss the topic for today. Thank you. Uh, Sir, one second, one second.
Good afternoon, namaskar to all my young, let me just shift here. Good afternoon, namaskar to all my friends here today. Thank you so much for this opportunity, for this privilege to be here. I've been the executive member of the Dslsa for a long time, for almost 10 years. And I can tell you that I have been involved in, though not for a recent past, I've been involved in the teaching aspects of the Dslsa functioning for a while, because when it was promoted about 5, 7, 8 years ago, one of the issues that was risen was, why do we need to train or discuss or debate with legal aid lawyers? And the answer that was given, and it was a very wise answer by the then chairman, he said, look, as long as we debate and discuss with our lawyers, the ideas that are going to go out, the quality that's going to be engendered, we will learn from them, they will learn from us, and together we will grow. Today, all of you are in the legal aid panel. Tomorrow, you will be doing your own practice. So the whole concept behind this discussion, and I will not just call it a training, is an exchange of ideas. I will probably learn more from you by the end of it today, and I'll be grateful for that. But today, I'm going to share some thoughts. Just to share with you, I have had the advantage of now doing about 13, 14 odd hearings in the High Court, not only Delhi High Court, in the Uttarakhand High Court and the Supreme Court. I've not had the occasion post-COVID to do a hearing in the trial court, but prior to that, I've done video conferencing with the jail, with the people in jail as a special prosecutor before the special court in Patiala House, and I've seen it. And I can see that since the pre-COVID time to new COVID times, the kind of challenges that have arisen and how we are trying to meet the challenge. I can also share with you that the first case that I did in the Supreme Court, perhaps the second, was a case where on the first occasion, video conferencing went well. On the second occasion, I and the judges were in one small corner of the screen and we could see each other. On the third occasion, it all failed. And finally, Justice Nageshwar Rao called us, me and the state counsel, and we had a conversation on WhatsApp on a video call. And that's how the hearing went on. And that is how the interim order was granted. And it was, I'm told, reported in the media also. So this is the kind of challenges we've had. Contrast that with what is now happening, where we are put in a waiting room and then we go and argue matters, or in the Delhi High Court. And I'll tell you the most fascinating experience, and I was going to share this later, but I will start by telling you now, has been in the Uttarakhand High Court, where on Thursday, I've argued a matter in Nainital High Court sitting in Delhi. I wish I could be in the lovely weather of Nainital, but I was in Delhi. And it was interesting and fascinating because the clarity of line, the clarity of hearing, we were all, and it's an open court. Unlike Delhi, where you don't have journalists, don't have access, people don't have access. In the Luthra High Court, they use a thing called JITSI, Jitsi, and anybody can click on the link for the court and be in the courtroom. Of course, the admin has the opportunity to mute all others except those who are arguing the matter, but that is necessary in these hearings. But it's a very fascinating way that we have replicated in some high courts a complete open court system, which is a constitutional mandate, which is the mandate of access to justice, which is a mandate of a free and fair trial for anybody. And that becomes very interesting. So today, I'm going to share with you a presentation which I made, and we'll go along that. So give me just a few moments while I get on to the presentation. Entire screen. Today's talk is about the role and responsibility of a criminal law practitioner during lockdown. Having practiced civil law and having practiced criminal law, I don't like the term criminal lawyer. It makes us out to be bad people. I always call myself a practitioner of the criminal law. I believe the role of a criminal law is far, far more sensitive, because while civil lawyers deal with property, with assets, and sometimes liberty, criminal lawyers' complete role, rather a lawyer practicing criminal law, is essentially and truly dealing with the liberty of an individual. And that is what it sets him or her apart. So today's talk is going to be during the lockdown, what has happened, what do you have to look at, what are the challenges that time is going to bring as proceedings open up. Mr. Arora very kindly, very rightly said that these are challenges. This is the new normal. Before we started this presentation, before we started this session, he and I were speaking briefly, and we couldn't complete the conversation about how long this will go on. At a conservative estimate, a few months, maybe a few months. But perhaps it may take longer, because by the time the vaccine comes in, unless we develop herd immunity, because right now we don't even know whether herd immunity works. By the time the vaccine comes in, by the time things get back to normal, One of the things that's going to remain with us is virtual courts and the technology that works with virtual courts for two reasons. It has its advantages. For example, West Bengal. Today, West Bengal is completely damaged or substantially damaged with the cyclone. As communications come back, the restoration of buildings will take time. But if we could provide a virtual court system, don't you think, friends, that we could reach a time and a place where we would be able to deliver justice at the doorstep of citizens and individuals? And that, I believe, is a very important requirement, because one of the things that we have not been able to do adequately, and that is because of technological issues, is we have not been able to deliver access to justice to the broad section of society which was entitled to it. Efforts are on. We have gone leaps and bounds from where we began on the day the lockdown was announced. And today, court proceedings are substantially seamless, and judges are very, very understanding and cooperative. I've had at least 3 hearings where the lawyer was at a remote location. He had a signal problem. The honorable judge said, "Don't worry, young man or young woman, I will call you." Took the person's number, called them on their mobile number, whether it was a landline or a mobile phone that was accessible, and had a conversation and put it on speakerphone so we could hear the nature of arguments being made on the landline. And that is the extent of adaptation the system has done. In a criminal proceeding, you have an FIR, investigation, arrest, bail, filing of charge sheet, closure, cognizance, supply of documents, framing of charges, and then prosecution evidence, statement of accused, defense evidence, final arguments, judgment, and sentence. As we move into the virtual court era, the first inquiry part can easily be done till the charge is framed and trial begins. We can also have final arguments, admission denial of documents, statement of the accused, arguments on sentence. All these issues are apparently possible. I can share this with you because I have had the occasion to address the Supreme Court in a 2-hour long hearing on video, the app, and we had a 2-hour long hearing where lawyers joined in from all over the country. It was a contempt hearing, and the final judgment is also, the sentence was given the same day. But that hearing took 2 hours and it was seamless. The problem that we have is within India, there are many Indias. A court in Delhi does not have the same infrastructure as a court, let's say, in Bombay or vice versa. The High Court of Uttarakhand, as I told you, has, according to me, the easiest possible connection. You go to the website, you click the link, and you're in the virtual court. In Delhi, we find district courts have been trying to ramp up infrastructure and increase the number of cases they can hear, but they have to hear evidence. So that makes it totally a special environment. The Delhi High Court services, WebEx, according to me, is far superior than the Supreme Court used to be, which is video, but now Supreme Court is also upgraded its services. So all these are part of a learning curve, and these challenges are something we're meeting. Because there are different softwares, the procedures are different, the formats are different. Prior to the lockdown, I've been appearing as a micus in a matter where we were trying to have procedures which would be processes all over India would be similar in terms of filing and listing of matters. That is the matter which was going on. It's a suo motu petition which the Chief Justice has called for reports from everybody, from all of the states, and that matter is on. Today, I find that there will, once the court reopens and that case is taken up, there will have to be a new element. We'll have to see how we can standardize VC hearings. So it is not that each time I have to access a software, I have to first go and try and download the software, ensure its compatibility with my device. It should be there. Sometimes it is not there. And only after that can you get rolling. As I said earlier, there have been challenges in the high courts. Sometimes people have not been able to communicate properly. And speed and quality of communication is crucial for conducting hearings via VC. If the judge can't hear you or you can't understand the question of the judge, we will be wasting valuable time both for ourselves, the litigant, and the system at large, because there are many people in the queue. And as Mr. Arora said, we have not been able to cater to the people who require justice for 2 months, and now we are trying to ramp up. And as physical courts will open, there will be a lot more pressure. But if they don't open in the near future, it is our duty as those who provide the service of law to the litigant being the beneficiary of that service, we must ensure that we must make the process as simple and as easy and comfortable as possible, and to ensure that access to justice is not lost at all. There are certain concerns that will come up, which are security of software to conduct hearings. So there are concerns of tampering, hacking, recording. In the initial hearings, I used to find lawyers would start taking photographs of their hearing. One day, I'd argued a matter, and there was a counsel who sent me photographs of my arguments, because in the chat room, everybody could see each other. Now, of course, the video is switched off, the sound is switched off, and people can't speak. There's a threat of identity theft. And the adherence to open court is by and large missing in most courts. But as I said, there are steps forward. The Supreme Court allows 3 journalists to attend the journalist room to see what is happening. And Uttarakhand High Court is open for all. And similar is going to be the trend as time comes on. Today, our scenario is the system has not come to an end. It may have paused for a little while, but arrests and remand continue. Police report, challans, charge sheets are going to be filed because there's a time involved. And at every stage, it is for the counsel, and more so for a legal aid counsel, who caters to the needs of the underprivileged, who caters to the needs of those for whom access to justice matters most, but they don't have access to justice. But for the legal aid counsel, it is for them and for you, that is, to ensure that all rights of all citizens are protected, and rights not only of the accused, but also of the victims, because you may be representing victims at certain stages. As trial court opens up, till infrastructure is in place for evidence, there are certain proceedings that are going to be carried out. For these, you'll have to understand, how do you study, how do you have access to records of the case in electronic form? I must share with you, one of the challenges I've had is people send me these electronic files. Now, you have to understand the technology. People send you a link. You have to then press on the link and download the file, because otherwise the file can't be handed over. Today, of course, physical files are being sent, but some people are wary of accepting physical files. So to read a file in its electronic form, to mark it in its electronic form, to bookmark it, bookmarking is possible, to make notes, perhaps on a piece of paper, to write the page numbers. A lot more meticulous study needs to be done to maintain the speed that we are able to maintain with multiple files, physical files in a court. So let's say you have a device which is 11 by 11 or 10 by 11. It's a small device. The speed to move the pages may not be as much as you move when you're physically, but you have to do that. Physical courts allow you to hand over records. So many times it happens कि आप बहस कर रहे हैं, अरोड़ा साहब के सामने बहस कर रहे हैं, शेयर जी के सामने कर रहे हैं, और लास्ट मिनट पे जज साहब कहते हैं we need a document or a judgment on a point. So what do? You send your munshi or your junior, who will go running to your bag, pick up a document and carry it, and you'll tender it in court. Or you will carry over a judgment मंगा लोगे आप library से, district court की library से, high court की library से. Today that can't be done. Today our preparation must be such, time being limited in VC, that case law, statutes, and relevant documents have come. I must tell you what some of the courts are doing. Realizing that documents are can't be physically filed, courts have permitted also e-filing. So sometimes I find that we have sent documents by email to the registry, and they have been much more prompt than it was in the physical document stage, because it's processed faster, it's moved faster. And some courts, we get a message almost at midnight, at 1 or 2 o'clock in the night, they create the group of people, so you know how your matters are going to be taken on. You are all aware of the Supreme Court and the High Court's directions. So there have been directions to prison authorities for overcrowding. The Supreme Court has ordered states to consider releasing. There's a Delhi High Court decision on 23rd March. There were high-powered committees set up. Physical presence of under trials have stopped, and that's a big concern. Transfer of prisoners stopped. Maximum possible social distancing in jails. And today, things are changing. But in the absence of physical presence of under trials, a challenge is how do you get instructions? How do you get information? The Delhi High Court, of course, has allowed release without surety in some cases. COVID prisoners can't be released. Directions for interim bails to under trials. And Delhi High-Powered Committee allows prisoners to communicate through telephone, but no jail visits, and that's natural. And then there are also problems of litigants. Recently, for a very poor litigant, we got the person bail from the High Court, interim bail, because there had been a bereavement in the family. The man goes out of town. He wants to come back, and the Delhi authorities say you can't come in, you have to have a 14-day quarantine. Now we had to move the High Court again to get an application for him to be given a pass for him to come back to jail. Otherwise, he would have defaulted and warrants would have been issued. Let's start today with the processes where there is a role of counsel. Production gives a person in custody access to counsel through VC. This enables counsel to seek factual instructions, prepare for trial, develop strategy, jail visits being on a hold. And at the time of VC, we now face a new challenge where you have to convince the client that we are in a confidential environment and that the client must have confidence while seeking instructions. You have to create that confidence. You have to make sure that your arguments at remand hearings are effective, are sound, because more than ever, the reduction of period in custody has become very crucial to protect not just liberty, but health and life. Once cognizance is taken, you need access to the records. In the good old days, we would have access to the original record of the police report, the charge sheet, the challan, and things would be very smooth. Today, how do you know what is in the original, what is not? And that's one of the issues that will have to be developed as time goes by, because you can only argue a trial or cross-examine or do a final arguments as long as you know what is in the original and what is not in the original in the record, what has to be summoned, whether there are deficiencies in copies. And this becomes important because you also need to know not only the police report, but what are the not relied for documents, because they become important for the purpose, because they may be exculpatory, they may prove your innocence, your client's innocence. So the first stage I think is very important is the ability of legal aid counsel to have access not just to the electronic copy of the charge sheet that is provided, but also to try and seek an electronic inspection of the challan, and that will have to be made available. And once that is done, to ensure that the 207 compliance is there, to ensure that the documents are there, to ensure that the material objects are there, they are sealed, they're in proper shape. Then the other stage, which is going to be very important, is going to be charge. In a magisterial trial, you can make a statement at charge. This will have to be provided for by the court. In a police report case, arguments have to be addressed. And both cases, the presence is needed to record a plea of guilty and not guilty. At this stage, without access to your client, whether he's in custody, he or she is in custody, or even if they're at liberty, there has to be meticulous preparation, and the records have to be shared both between you and the clients, because physical meetings are nowadays restricted. Even when the lockdown opens, there is going to be a concern for a certain category of counsels, people who have either a lifestyle disease or people who are a little elderly, who are very competent, but they have to be, they have to take a lot of precautions for the months that come, for perhaps the year that comes. And therefore, a lot of this exchange is going to be electronically. And therefore, we have to learn how to deal with data and material electronically. I remember when I was studying in England way back in 91, I was doing my master's. At that time, computers had come in somewhat in India, and they were coming in England a little more than India. And I was working on an Apple Macintosh. That time, they had not come to India. And there used to be in our university very good machines. and I made a very large file. I didn't know that a 6,000 word file, today 6,000 word file is a common thing. That time the programs did not support it. So I was writing out my master's thesis with my one finger typing painstakingly, and I made this very bulky file. And suddenly, before my eyes, 15 days before my thesis had to be submitted, the file crashed. I was very stressed out and I was almost at the verge of tears. I probably was crying. I was in shock. And then there was this somebody else from the college, a student who coincidentally happened to be from the computer department. He was studying computer science, and he left his work and spent half an hour with me, but we managed to retrieve most of the file. And then I slept. But that's the kind of change we have to do. And for me, as Mr. Arora said, I've spent 30 years. It is time for this old dog to learn new tricks. And I'm trying to learn the new tricks of the technological world. And therefore, I would commend that so do all of you. If we have to survive, if we have to serve our clients, we'll have to do that. Another stage is going to be 294. This is definitely going to be possible. Consultation of party is needed and counsel is needed, because you have to realize what to admit, what to deny. And this is another important stage, which is very important. It can change the nature of defense depending on if there's an erroneous admission or if there is a denial of something which is a basis for a defense or exculpatory in nature. 330. Even at the 313 stage, the presence of accused through VC, I'm sorry, the word VC seems to be missing here, through VC is important, but there has to be, and the systems will have to provide the ability to confer with counsel or to give counsel permission if the client is not in custody, to give him or her permission to speak to the lawyer offline, so that while stating the defense, there has to be no inaccuracy. Fortunately, our system provides for written statements to be filed, and today, more important than ever before, the value of the written statement has gone up. It has become very crucial, because even if there is some gap in the questions, the written statement can be a comprehensive answer to the last question put in 313, which is, what do you have to say? I believe that you are also gearing up for final Now, let me share you with my experience what I've seen in a final argument case so far. The time is fixed. Judges will not allow you to go on and will not be able to go on and on, because there are people waiting in the queue and technology has its limitations. So there must be optimization of opportunity. You should try and prepare a proposition note with case law. We often do this, at least in the Supreme Court, even in the trial courts. Proposition, in each final arguments case, the proposition and the relevant case law. You can do this at the stage of charge or any stage when a miscellaneous application is argued. But at the final argument case, if you can have your propositions, cull out the relevant evidence, put them together, proposition, evidence, case law, proposition, evidence, case law, and make a brief written note, apart from the perhaps elaborate written arguments, they will not be a substitute for oral submissions, but they will definitely supplement the oral submissions. Just as I've shared with you this presentation, you will have to have soft copies of exhibits, soft copies of the case law, soft copies of the evidence, so that all of them can be shared contemporaneously. Recently in a case, we had a problem where the judge, we tried to share a document, it didn't get shared, and I could only find one solution. I had it on my iPad, and I showed the judge from the camera my iPad, which contained it. In another case, we had to turn around our laptop and say, we've got this document and email on our screen, please see it. The phone print was too small. So that's the kind of changes that we have to adapt to and think of. Now, this is so far as what can be done in the current scenario. But we are going to face new challenges. My sense is it is only a question of time before trials begin. The courts are trying to ramp up their capacity, and whether it is by ensuring that witnesses come to specific rooms within the court complex, or that they are otherwise in a secured environment. But it is time that we should realize that evidence is not that far away. One of the concerns is going to be the presence of the accused, which will have to be dealt with because the accused has a right to be present. Some systems earlier did not allow. Now most court systems give a line for the litigant to join in and to see the proceedings. Presence of a witness in a secured environment, free from influence of prosecution, accused and complainant. You don't want the witness answering questions as tutored. At the plea bargaining stage also, there are going to be challenges regarding appearance. Now this 273, presence of accused, is very important. This, the advocates or the victim's counsel, there is always an interplay in their dealings and with that of the witnesses or the witnesses, because that becomes very important as a pulse as to which way a cross-examination may or may not go. The interplay between all of these in the absence of physical presence is very important because we need to understand the psychology and mental makeup of the witness. We also have to ensure that demeanor will have to be recorded by the court, because demeanor becomes more and more important, and it is not always easy to make out demeanor. So perhaps the provision regarding demeanor may have to be revisited in the context of virtual courts. Confrontation of documents is very important. How are we going to confront documents? These are challenges which are going to happen, and we will have to have access to the original records of the court, and we will have to have trained staff who will be able to put them up, or you can do a screen share, and based on that, the honorable judge will be able to record the document as an exhibit or a marked document and put it to the witness. There will have to be great deliberation on how to be effective. We need to record objections. Objections are decided at the end of trial. Now in VC, there is one very interesting peculiarity. One speaker at a time, so the question can be asked and sometimes answered before objection is raised. So when you speak, you ask a question as a lawyer, the witness begins to answer it, and before you've written your objection, sometimes the answer comes. So we'll have to develop a mechanism where the honorable judges will have to ask if there is any objection to a certain question, and then proceed, and judges will have to be very vigilant on the recording of objections. Marking exhibitive documents, I've told you the challenges, and the fact that all of this, unlike a real court where things are smooth and where we're used to working, it's going to be time consuming. You know, this business of one speaker at one time on a VC is very interesting. When I started practice a while back, and as I've seen over the years, only one counsel used to speak at a time. In any court, never was it that more than one lawyer spoke. Today, that practice is no longer the norm. From the Supreme Court to the trial court, and from the trial court to the Supreme Court, multiple lawyers are speaking at one time. Although recently in a hearing before a division bench of the Delhi High Court, I found that Justice Hima Kohli had no option. The division bench had no option, that because all the lawyers were trying to speak at the same time, she had to mute everybody, then speak to everybody and tell them, I muted you all, now you will listen to me. Please speak, please raise your hand, speak one by one. If everybody speaks, I can't make out and the proceeding will be lost. And that will become the old method of self-discipline will now have to be practically brought back, because otherwise we will not be able to carry out any proceeding effectively or fairly. There are other challenges. Defense counsel sometimes adopt a line of question which is challenging relevance. In a courtroom, judge used to say, all right, let the witness stand at the back and would call the lawyer in front. Today, it can be done by VC audio, video audio muting. Witnesses are also not used to electronic courts. So that discipline will have to be brought in within the system. Sometimes you want to record objections. In the traditional method, if the judge doesn't record the objection, you would move a miscellaneous application. As my late father used to say उस समय कि ₹1.25 का प्रसाद, ₹1.25 की टिकट लगा के आपने दरखास्त दे दी कि साहब ये क्वेश्चन पूछा गया था, इसको नोट कर लें और विटनेस ने ये ऑब्जेक्शन मेरी नोट कर लें इस क्वेश्चन. अब that can't be done. So we will have to keep pro forma applications ready where you will quickly write out or type out the question on another device and then upload it. And you will have to have an assistant counsel to do that, possibly, or an assistant junior. the court atmosphere is not present. You've seen the case where a lawyer came in not properly dressed. He was wearing a vest. There are people who have come in wearing shorts on court. And I must tell you, you have to be properly dressed. From my perspective, even though the relaxation has happened in terms of clothes, but I like to be dressed properly. It gives me a sense of purpose. It gives me a sense of solemnity of the occasion to be able to do my best and not to be casual about it. And that becomes very important because now we must optimize and maximize the benefit our litigant is going to get from this. And if this court atmosphere can be replicated by lawyers being appropriately robed and conducting themselves appropriately, perhaps the solemnity of court will come back and witnesses and accused and victims will all conduct themselves in a little more formal manner. There are going to be opportunities. I'm going to deal with the opportunities now and then come to the section on bail because I didn't want it all to be so gloomy. So I thought I'll give you a little break by dealing with the opportunities. Normally, cross-examination requires a number of people in court, 6 to 16 between court staff, junior lawyers, counsels, etc., etc. But today, time limits are prescribed. So you have to be crisp in what you have to say or do. Adjournments and passovers are sometimes possible, not always, because with fixed time slots, if the matters carry on for too long, today, of course, passovers can be granted, but I think there's going to be a stage when passovers will not be granted. And if that happens, it is an opportunity for a greater number of lawyers to excel. Not only the seniors who maximize their presence, but young juniors will get an opportunity. Recently, there was a matter where Mr. Mukul Rohtgi and I were appearing in a matter, and after coming online, for some reason he switched off and then he couldn't switch off his video. So he couldn't switch on the video and the judges couldn't hear him. And I had to carry on with the hearing, and then he's decided to make some additional submissions. But the judges pointed out to him that Mr. Rohtgi, we can hear you, we can't see you, we need to see you as well. So by that time, I'd argued most of the matter. So this kind of thing can happen. And this is the kind of challenges, and younger lawyers, I would say, have this great opportunity, and it's time to try and excel. Examination of witnesses enhances the level of protection provided to all, especially vulnerable witnesses, by limiting physical proximity. So they are in a safe environment. They don't need to confront the accused or the victim's family who may be hostile. And that becomes very important for both prosecution and defense purposes. VC also enables distance. Distances become irrelevant. Sitting in Delhi, I told you I argued a case in Nainital. Why can't this be done for expert witness sitting in their lab? They can go to the local court, go to the room, have a fixed time, and get the evidence recorded. The examination of experts, scientific witnesses, police officers can be convenient, and there's going to be a lot of speeding up of time and no travel, no scheduling, and costs for litigation are going to be much, much better, even from the purpose view of the legal aid authority. When lawyers don't need to travel, they don't need to spend that extra time on travel time, on petrol, other expenses. Now that was so far as the challenges and opportunities are concerned. The last part of my talk today is about bail. Bail, anticipatory bail, cancellation of bail. And I'm going to talk to you about some of the issues that arise. Bail, as you all know, is non-bailable offences, is not a matter of right. It's of discretion. The traditional parameters used to be seriousness of crime, absconsion, obstruction to a fair trial. There was always a balance to be made between individual liberty and maintenance and safety of public interest and public order, because judges are very concerned about this, as they ought to be, because that is one of the parameters of bail. Today we have directions of the High Powered Committee, we have directions of the courts requiring a proactive role of legal aid advocates. We're not just looking, friends, at liberty, but we are looking at the life of immunocompromised and the elderly, and it's sacrosanct. There are people in jail who are immunocompromised. There are elderly people in jail. I have a bail application coming in the Supreme Court for an elderly person on Monday. And judges are concerned that whether such persons, by keeping them in jail, though they may ordinarily need to be kept, their life is at risk. Legal aid counsel cannot limit themselves to waiting for such mandates. It is time for you to proactively seek relief for prisoners falling in the prescribed categories and prisoners with ailments which are immunosuppressant and create risk for safety in jail. There is enough data. For example, diabetics. A diabetic or a person with a lung impairment or a lung disorder or a person with other pulmonary issues or a person with, let's say, tuberculosis or even a person who is a cancer survivor, heart patient, blood pressure, all such persons are at risk. The elderly are at risk. And therefore, we have to be very careful in being very active to ensure that their rights are protected. Then you have, once arrested, once detained, you have to be produced within 24 hours. That's the constitutional mandate. But today, because of restrictions, lockdown, of course, has opened up. But because of lockdown limitations, courts not being available, we don't want a situation where police officers get away with an excuse that they could not reach because of COVID. These must be very carefully tested and seen because it is a constitutional mandate which cannot and ought not to be allowed to be breached. Remands are very important. As I said earlier, I touched about it. Today, what is the practice normally in serious offences? Very often in serious offences, we say, all right, please give police custody for as long as you can or give judicial custody. But today, custody has not only liberty implications, but health implications, life implications. Therefore, every remand must, on the principles of remand as set out in the Delhi High Courts and the Supreme Court decisions on the point, and the High Court decisions, must be fought to say what is the justification for remand. Because a remand to custody can mean a breach of social distancing, jail or a police lockup, whatever it may be, cannot provide the safety of our own environment. But at the same time, there are people who are going to be remanded because of the nature of offense they've committed. So all of this has to be seen, and at time of remand, we must ensure that the medical condition of a litigant or his age or his other limitations must be highlighted. So the judges are sensitive and pass appropriate orders to ensure the medical safety of the individual. Because investigations are not going. I did a case yesterday where in Bombay, in a molestation case, the statement of the victim had not been recorded. Now, if the statement is not recorded, the person is in custody, bail is likely to be granted in default bail. Why are we not willing to work at taking advantage of these for our litigants? Because that's a very important effect. Laws, of course, certain laws extend that period, but I will not go into that. So we must be very cognizant of the period of 60 days, 90 days, or 30 days, or 180 days, or 90 days, 180 days, and we must act on that basis. There's another area which I want to share because there has been some development in the law in 2018-19. Sometimes your clients have been arrested for bailable offences. Today, non-bailable offences may be added. The moment this gets converted, the bail granted in a bailable offence will not extend, but a person cannot automatically be arrested and they have to approach the court. There are two classic decisions, Hamida versus Rashid and Pradeep Ram, the 2019 decision. I would commend you all see these. You all deal with these daily, 437, 439, the powers of the magistrate, session court, and high court to grant bail. No limit on the number of applications. And today, I would submit from my experience that medical conditions, COVID, even though they may have been rejected in the past, have become a new condition for grant of bail, keeping in view the COVID parameters and the fact that a person is maybe in danger of life or health. So merely because there is no urgency, merely because there is no immediate need of a surgery or procedure, because those were the grounds for interim or regular medical bail earlier. Today, the infirmity which is provided in 437 and considered in 439, infirmity, ill health, age are very, very important parameters, and we must act proactively to bring these before the knowledge of the court to the knowledge of the court so that we can gain benefit for our litigants. Now, this is just a short presentation. I've added to this that health infirmity should be ground, so I'm not going to repeat this. But one request for those of you who are aware of the High Court rules, I'm very grateful for that. But do visit the High Court and revisit the High Court rules. Today, the expeditious hearing of a 437, as prescribed by the High Court rules, is more important than ever before. Who can be granted bail? The person must be in custody. Supposing you are on interim bail and your 437 gets rejected on merits, you have to move under 439. Traditionally, the way was you had to be in custody. In 1980, in Ranjan versus Prabhakar, this was clarified. Later on, this judgment was said to be not good law, but has recently been followed in Sandeep Kumar Bafna versus State of Maharashtra. Now, one of the questions that's going to arise is, the court is closed. I can't go to the court. How do I submit to custody? That's a challenge which you will have to battle with. And as time develops, there are going to be developments in VC court jurisprudence, as I may call it. These are broad parameters for grant of bail. All the others are parameters you know, but let's test them one by one. Pre-COVID and post-COVID, enormity of charge has not changed. The nature of accusation will not change. Severity will not change. Evidence should not change. But the question is, will the witnesses be able to come? And will trial go on and will there be delay in the trial? That's 6, protracted nature of trial. Can the trials actually go on? Today, dates are being given after 2 months and we don't know how soon trials begin. So that becomes a ground for bail. The danger of witness tampering, destruction in a COVID lockdown, where is the question of destruction of evidence? Courts are closed, witnesses are at their home, so this parameter today, the objection based on this parameter becomes almost diminished. Opportunity to the applicant for preparation of defense. If you don't come out, you don't have access, jail visits have stopped, family visits have stopped. How does a person access counsel to prepare for the trial? Most important, the health, age, and gender of the accused. The nature and gravity of circumstances is an old ground, remains valid. Position and status with reference to the key victim and accused, yes, that's valid ground. Same family or same neighborhood. Probability of accused committing more offences if released on bail. Sahab, everything is locked down. Where will the person commit an offence? And therefore, even interest of society, number 14, is not going to be objected to for people who are released on bail a little more liberally. For that, you have to do the homework. The next section is going to be about anticipatory bail, because I understand we have certain counsels from the High Court and Sessions Court as well. We know anticipatory bail is a pre-arrest remedy, confers immunity from touch or confinement. There has to be a general apprehension. The court must get a belief that the applicant will be arrested. In a matter I was doing before the Supreme Court, the judges asked the counsel, my anticipatory bail had been rejected both in the trial court and the High Court. So they asked the government counsel, are you going to arrest him in this time? And the answer obviously was, we can't. So the SLP has been listed immediately after vacation. Courts must really also satisfy themselves whether a person is actually going to be arrested, because if arrests are not happening, then why should you stress? Initially, an interim bail is granted, notice is given, etc. And at the final stage, the conclusion can be either way. The most important ingredient is reason to believe. We know what traditionally reason to believe meant, a reason of arrest. But today, it's not just fear of arrest. It's fear that if arrest happens and you're put to custody, your life may be in danger. There are other parameters that's not being named in the FIR, etc., the FIR being registered. But these are matters of practice, including that of concurrent jurisdiction. There are certain laws which exclude anticipatory bail. For example, the Scheduled Tribes Act. This, of course, has been, there's an exception carved out on Prithviraj Chauhan. And there are other provisions such as the MACOCA or the erstwhile TADA and certain provisions of the UAPA. Anticipatory bail was sought to be interpreted on Balchan Jain. Then we had the Constitution Bench in Gurbakh Singh Sibia, which said that it's complete case of discretion. Let judges decide broad parameters, but we are not going to give guidelines. And of course, pre-FIR could be moved, etc., no limitation period of time. Sibia lays down these 5 principles. Reason to believe does not include mere fear. Courts must apply their own minds, cannot leave it for the magistrate under 437. Filing of FIR is not a condition precedent. Anticipatory bail can even be done post-FIR as long as you are not arrested, and cannot be invoked after arrest takes place. In 2005, it's been amended. They tried to bring in the parameters more or less in line with Sibia's case. In the meantime, you had Salahuddin Sheikh, you had KL Verma. These were the conflicts which went on for about 10 years. Maitre clarifies it. Maitre says this is not correct. Sibia is the law. These judgments are wrong. Post 2011, there was a conflict, went to Sushil Agarwal, and the Constitution Bench in Sushil Agarwal has now said no outer limit. There can, of course, be limits set, but for that you have to have good reasons. And the normal rule is anticipatory bail will not be limited in point of time. Again, Justice Bhatt gives certain parameters, which is really a repetition of what was said in Sibia, because both judges, Justice Shah and Justice Bhatt, rely on Sibia completely. The question will have to be seen what the 2005 amendment, what the impact that will have. But on terms of discretion, they rely essentially on Sibia, and that's the interpretation that now holds good. Certain special laws provide for bail, but they have conditions in addition to those covered, and those statutes have what is known as twin conditions. So these may have a special nature, severity, the prosecutor has to be heard, and the person must be in custody. The person at the bail stage has to show innocence or that they've not committed an offense. A very high burden to meet, especially at the investigation stage. Of provisions like this illustratively are Section 37 NDPS, Section 43D5 UAPA, 212 of the Companies Act under challenge in the Supreme Court, 45(1) of the PMLA already being quashed. Why was it quashed? Because it was found to be violative of 14 and 21. PMLA has been amended, though the Delhi High Court says that the amendment does not take away the mandate of Nikesh Tarachand and they'll continue to apply. As I said earlier, there are other challenges pending. Then you have my last section for the day, which is cancellation of bail. Now, when can bail be cancelled? It can be cancelled when it is believed that there's a supervening circumstances, when there are overwhelming circumstances, when a person has tampered with evidence, hampered investigation, intimidated, destroyed evidence, run away, fleeing from jurisdiction, and can be cancelled if there's a misrepresentation of facts for procurement of bail. But this in the COVID era, how are you going to say somebody's going to flee? Very unlikely with the kind of restrictions we have. So I'll give you an old anecdote. Many years ago, we were arguing a matter where I was appearing for a case from Punjab, and one of the co-accused was the current Chief Minister of Punjab, Captain Amrinder Singh. And the challenge was that he would flee to London because he had property and assets in London. To which I remember the Supreme Court bench remarking, please remember he's the Maharaja of Patiala, he's not the Maharaja of London. Where will we go? He's not going to leave his asset and estates here. Today, who can leave their homes? So these cancellation parameters have also in that sense got affected in part. There can of course be a quashment of bail orders, and we have to be very vigilant in such cases. If you have a victim's counsel, we have to be vigilant. If we are accused, we have to be vigilant. But here, it's not just on post-bail conduct and supervening. What we are really looking at is that the parameters for grant of bail were wrongly granted. Post-bail conduct is relevant for the purpose of cancellation of bail, not for quashment of a bail order. So with that, I'm going to finish today's talk, which has gone on for a bit of a while. And thank you so much for this talk. I hope that I have been of some use to all of you.
Thank you, sir. So we have more of appreciation that people were quite different. I'll share one of the comments which we have got. So your PPT has very well explained us, given us the comparative study of criminal practice, criminal procedure, rules, and updated technology. Wonderful presentation. So we are yet to receive. We've received one question. I'll put that to you, sir.
Please.
Very true, and your PPT explaining everything. So there's more of a praise.
What's the question, if I may ask?
Andy sir, that's on section 327 CRPC,
Mhm.
where which it states that the court needs to be open. There's this advocate who is Mr. Akshay Sharma. He has written this question. I'll
Can
just
you be a little louder, please?
yes, sir. So his question is that he's saying I'm perturbed as to whether we
Perturbed
are
as to whether we are
neglecting the
neglecting.
basic idea of yes, neglecting section 327 CRPC, which talks about court to be open.
Mr. Sharma, I think that's a very important question, and I'm grateful for that. And it's caused me some amount of concern and consternation because I believe uh, there are two things which I want to share with you. Open courts is not an absolute concept. After all, today, if you want to enter any court, can you enter without an identity card or a pass? Can anybody walk into court and have access to documents? So, therefore, we will have to, in the VC era, balance the open court concept with the concept of privacy of the individual. Let's say a litigation is going on. Anybody can check there's litigation of A versus B. You check there's A versus B, you know the parties, it's hundreds of people. Let's say it's Rajkumar. Rajkumar versus Om Prakash. Hundreds of Rajkumar, common name in North India. Om Prakash is equally common. Unlike in a real court, where even if you enter the court and you can see the proceedings, you can't have access to the records. In a VC, there are serious concerns of privacy. Because in a VC court, if we will have to have an open court, undoubtedly, and I'm all for it. It's very important that there be an open court. And the requirement of being an open court is a great corrective both on judges and on how lawyers and witnesses conduct themselves, and even how accused conduct themselves. But having said that, what is very important is we are flashing documents on video conferencing. They have the details of a litigant, they have the name of a litigant, they have the address of a litigant, especially in certain cases where identity is to be protected. So all these will have to be nuanced and worked out. So open court must be given full place, provided with protection for privacy. The Uttarakhand example I gave you, my recommendation is go to the Uttarakhand High Court website, try the court. It's an amazing experience. You press the link, no software download, go there, and you'll see the entire court, and the lawyers are there. First, they're chitting, chatting, and then you can see the hearing go on matter after matter, and matters are called out, and item 2 is called out, item 3 is called out, and then lawyers are joined in, and it's a very interesting concept. Anybody can join. But again, there are issues of privacy there. So they will have to be, just as in, I mean, today, look at it, for example, how do you adhere to the open court? You have journalists who come in, but today journalists are also accredited journalists. Not any journalist walks into court. So it's not an absolute concept, but at the same time, if any VC court does not permit an open court concept to prevail, then we are being unfair to the system. Initially, in some of the courts, the litigant could not join in, a link was not given. Today, links are being given to litigants, and that's a very important move forward.
So there's another question by Advocate Seema Mishra. Her concern is that on first production, usually the accused own lawyer cannot be present as production is happening in jail. So what do we do then?
I think we have to ensure that legal aid counsel is present, because that has always been a problem. You know, there was always, it used to be a cat and mouse game between us and the police officers who would produce people uh, at odd times, and we would be running and we would know which court they'd be produced in. So that's always been a cat and mouse game. At that point, the High Court rules have a very important role to play. The High Court rules in Rule 16 or 16A allow a judge and require a judge to check whether why the person is not represented, whether they have appointed a counsel, whether they have a counsel who they want to contact. And at that point, it is for the judge to ensure that the access to counsel is not denied. And I would recommend that everybody looks at the High Court rules. In fact, you should do a session for all your legal aid lawyers on the High Court rules and the provisions of bail, remand, warrants. It's a body of knowledge which is very rich.
Truly, sir. We'll
And
do
they
that.
come from the Lahore High Court, and they apply to not only Lahore High Court, they apply to Punjab, Himachal Pradesh, Punjab, Haryana, Himachal Pradesh, and Delhi.
Great. I think another session now. So there's another question by Advocate Anupama. Does a video conference before a court itself can be made part of an electronic evidence under the Indian Evidence Act?
It's a very valid point. Of course, it's an electronic record. And nowadays, courts are recording all of these. Courts are recording all of these proceedings.
Hmm.
So, of course, it's an electronic record, electronic evidence.
We go
And
to
that is the reason the sanctity needs to be protected, so these videos don't fall into the wrong hands. Person wants a copy, he or she should be entitled to a copy. During any proceeding, a non-litigant, a person who's not a party cannot have a copy. It is only when the case is decided that the record becomes public to all, and that's part of the open court concept.
I think one more question by
Sure.
Vikram Singh. Please elaborate on the grounds of cancellation of bail and what documents are required for the same, holding the circumstances for cancellation.
Cancellation of bail, I would say it's best explained in a wonderful decision called Luthra, 95 Supreme Court. It's a wonderful decision, small, short, crisp, read it. Secondly, I would the grounds are really interference with witness, obstruction in the court proceedings, interference with the records of the court, abscondence or avoidance, as I said. So these are the broad parameters for cancellation of bail. They're all supervening circumstance, and they can all be applied effectively. But as I said again, today, for those grounds to seek cancellation of bail, you will have to have cogent material. Now, sometimes, especially in matrimonial cases, we find people generate a number of complaints between a husband and wife. One party will generate a number of complaints of threats and give them to the police and say, look, I've been threatened so many times. These are my complaints to the police. And judges sometimes go deep into those to see whether those are valid complaints, not valid complaints. And these are important parameters and considerations which must be seen. So please, Mr. Vikram Singh, see the judgment. There are other judgments. I've put one more judgment. I hope it's of use to you.
The last question.
Kaustubh Seth has a
So
question.
how does cross-examination likely to change with the existence of the e-courts, considering the physical presence and body language is important, which would be difficult? I think we
I
can
think it's a
discuss it.
great challenge. I think it's a great challenge because when we started these VC hearings, there was a very casual atmosphere. Now one has become used to this as a normal that you're sitting and you're in court, but you're at your own home. You may be wearing rubber chappal, but you need to be properly dressed still. So, so it's very important that we become disciplined. The only thing is the securing a witness in a arena where the witness is not going to be interfered with or not going to be tutored, and the sanctity of the witness testimony, and that the witnesses understands the sanctity of the oath that he or she is taking. It's very important. So whether you provide cubicles, for example, in every locality, you have community centers where there are cubicles where people can do all of this exercise. Send them a specific link which can be done, or have cubicle rooms in courts where people can come in and give evidence. So that kind of system will have to minimum physical contact, maximum efficiency.
True, sir. So I think I would invite our member secretary too now. He's here. Yes, sir.
Thank you very much, Luthra Saab. It was really a lucid explanation of what all of us need to do, especially our panel lawyers. And you have very clearly and elaborately explained all the challenges, some of the questions, as the last question which you were taking up regarding that how it's regarding challenge during cross-examination, because body language of that witness is important. And you have very validly said that we need to have some sort of system evolved for that, maybe cubicles and all that. So recently, two virtual courts were inaugurated. So far as traffic courts are concerned, by Honorable Justice Chandrachud, who is also heading the E Committee of Supreme Court. He also said that they would be constructing, having E-Seva Kendras in all the district courts throughout the country. Probably these E-Seva Kendras would serve the purpose, and having all these cubicles where witness can come and all those things regarding demeanor of the witness and body language, that can be taken care of. It was really good on your part to explain, besides the challenges which are there for recording of evidence, presence of accused, then presence of witness in secured atmosphere, confrontation of documents which you mentioned. And similarly, you have also explained wonderfully the opportunities which through VC we can develop, like vulnerable witnesses, they are free to depose in a secured atmosphere using this video conferencing. Then cost effectiveness, say it reduces the burden of, say, traveling long distances, as you appeared while sitting in Delhi in Nainital, Uttarakhand High Court. And one of the questions which you just clarified to Akshay Sharma, that was regarding open court and all that. The concept of that Uttarakhand High Court, Jetsi Meet app, which they are using, the thing is that this is also one of the challenges, that different high courts and different district courts are using different technology, and that becomes difficult for a lawyer to adapt to that technology before start arguing or appearing in that court. I think that we need to have a standardization, we need to have a uniformity of approach in all the courts. That would not only help the lawyers but also the litigants, as litigants also are being provided with the links. And there are certain litigants who have number of cases listed in different courts. So it becomes very difficult even for them to have different technology at different time to be able to appear in different courts. Definitely in these times of changes, we have all these nuances which are going to settle down. ये initial जो teething problems हैं, so उसके बाद the things would definitely settle down. But so far as these particular times are concerned, and in these times, the type of cases, as you said, that through VC we can have all those cases which are listed for final arguments, or even for that matter those which are at the stage of recording of statement of accused. You have rightly said about the importance of the written statement, the concept which was lately incorporated in that 313 stage. So all these things can be made to proper use by our panel lawyers. And one most important aspect was, as I think Seema Mishra, she had raised that at initial production, after arrest, the availability of defense counsel. As you said, that as legal aid authority, we have to ensure that at least our remand lawyer remains present there. For you, I'm telling that we are making sure that because of this particular period, the fresh arrestees are being produced in the jail complex, the court complex which we have in jail, Tihar,
Yes.
as well as Mandoli. So we are making sure that our remand lawyers, they are the ones who are deputed there, they remain present there, so that the person who is arrested and is produced before the magistrate has proper legal representation. He has something, whatever he wants to say, whatever he wants to address, whether we police custody should be given, not given, he can have the help of that legal aid lawyer who remains present there. So all these things, all these parameters which as legal aid authority we need to take, we are definitely taking. We are definitely, but rest upon this wonderful presentation, as I was reading the comments, it's basically very few questions, and most of our lawyers, they are just say feeling good to have such a nice presentation. The way you presented the things and the PowerPoint of yours, that was really wonderful. And thank you very much for sparing your time and the content. The way you prepared your PowerPoint, that shows the efforts which you have put in. So that is very clear. Very thankful for your time, your energy, your enthusiasm. And आप कह रहे हैं कि कुछ importance का, it was of much importance to all of us. So thank you very much, sir. Thank you.
Thank you.
Thank you so much.
Thank you. Thank you very much.
Thank you so much. Thank you very much. It's been a pleasure, and I'm grateful for the